Point. Oh, I, okay. I will start over. That's very loud, Louis.
Yeah.
I'm going to put it a little further away from me. Okay. I'm going to start over. Good morning. My name is Felicia Orth, hearing officer appointed by the Secretary of Environment to conduct a hearing in CHB 25-53R. These are proposed amendments to the hemp post-harvest processing rules set out at 20.10.2 of the New Mexico Administrative Code. The hearing will be conducted consistent with the department's rulemaking rules at 20.1.9 of the New Mexico Administrative Code. All documents related to this matter can be found on the NMAD Docketed Matters webpage under the New Mexico Environment Department tab there. We have one notice of intent to present technical testimony filed by the petitioner. And we had also some written public comment. Under the rulemaking rules, we will hear first from petitioner, then I'll invite public comment. All testimony is taken under oath and subject to cross-examination. Let's see, Mr. Knight.
Good morning. Andrew Knight for the New Mexico Environment Department, and with me is my witness, Jonathan Gerhardt. We are ready to begin. I just wanted to make sure that the court reporter is online and can hear everything.
All right. The hearing is being recorded and transcribed by Kim Schollenberger. Kim, can you hear us?
Yes, ma'am. And can you see me waving?
Yes, I can. Thank you very much. All right.
Before we proceed, may I ask one question?
Yes, ma'am.
And I don't mean this offensively, gentlemen, but I see on my small screen a gentleman in a gray suit with bald head.
That's Mr. Knight.
Okay, and the gentleman next to him is his witness then, correct?
Correct, Mr. Gerhardt.
That helps me.
Yes.
Thank you. I'm sorry for interrupting.
Absolutely. And if there is something that you don't catch given the hybrid nature of our hearing, Kim, please just speak up.
I will. Thank you, ma'am.
All righty. So, Mr. Gerhardt, would you spell your first and last name for the transcript?
Sure. Whoa. Yeah. JOHNATHAN GERHAR D as in David, T as in Tom.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Mr. Knight, go ahead.
I have a brief opening statement, if I may. Good morning, Madam Hearing Officer, members of the public, stakeholders. When the New Mexico legislature passed the Hemp Manufacturing Act in 2019, the intention was to create an industry that supported New Mexico farmers, giving them a high value crop, and that provided New Mexicans with domestically produced sources of non-intoxicating therapeutic products, such as those containing CBD, as well as food products, hemp fiber for clothing, etc. Then, just a few years later, came legalized adult use cannabis, regulated by a different agency, highly taxed, and most importantly, restricted to being sold only at licensed dispensaries to those over 21. Both of these agricultural industries involve the same crop, Cannabis sativa L. but there is a bright line between them. Anything containing 0.3% THC or less is legally defined as hemp. Anything above that is cannabis. Since then, we have seen the rapid proliferation of products claiming to be derived from hemp, containing synthetic and semi-synthetic cannabinoids. These intoxicating products have been sold in what was essentially an unregulated market, made possible by a loophole in the federal farm bill, which has thankfully since been closed, with a federal phase out of these products by the end of next year. We promulgated an emergency rule back in August to ban these products, and now we are here today to make that ban permanent. That is the first purpose of this rulemaking. Second reason we are here today is to generally update the hemp manufacturing rules. This project has been in the works since before the emergency rule, and it just made sense to combine them into one proposal, and the timing worked out, so here we are. We have a number of fairly minor but very important changes to the hemp manufacturing rules that clarify them and that address some gaps we have become aware of through working with permittees and our experience implementing the rule over the past several years. These changes generally make the rule more user-friendly while also enhancing consumer safety. With that, I would like to have our first witness explain all of the changes we are proposing and the reasons therefore.
Thank you. Please go ahead.
Please state your name for the record.
Morning, my name is Jonathan Gearhart.
And what is your current position with the New Mexico Environment Department?
I'm currently the Bureau Chief for the Cannabis and Hemp Bureau of the New Mexico Environment Department.
Is your resume in the record?
It is. It's attached as Exhibit 3.
And please briefly describe your history with the department.
Sure. I worked for the Environment Department in the Food Safety Program for over 20 years and began managing the hemp program in May of 2019 and have been the chief of the Cannabis and Hemp Bureau for over 3 years. During my time with the department, I've served as a food specialist, deputy food program manager, food and hemp program manager, and became the bureau chief upon the bureau's creation in 2022.
Do you have any professional credentials or certifications that you currently hold?
Sure, I hold several food safety related credentials and certifications, including the United States Food and Drug Administration's Commission and Credential, the FDA Retail Training and Standardization Officer Certificate, and the FDA Food Shellfish Standardization Officer Certificate. In addition, I've received extensive training and education in food safety, food defense, hemp and cannabis extraction, and manufacturing related topics. I also currently serve as the co-chair of the Association in Food and Drug Officials National Cannabis, Hemp, and Natural Psychedelics Committee. And as co-chair of that committee, I direct the activities of the committee both to enhance the knowledge of those regulating and working in the industries, and also promote the standardized regulation of cannabis, hemp, and natural psychedelics through organizing educational and training presentations, directing research efforts, collaborating with overlapping industries, and implementing the Cannabis, Hemp, and Natural Psychedelics track of AFDO's annual education conference.
Did you file written testimony in this matter?
Yes, it is attached as Exhibit 2.
And have you reviewed that written testimony in preparation for today's hearing?
Yes, sir.
Are there any changes or corrections that you would like to make to your written testimony at this time?
No, sir.
Do you therefore adopt your written testimony with as your testimony here today?
Yes, sir.
Okay. So we're going to summarize your written testimony today for the hearing. What is the overall purpose of your testimony?
The purpose of this testimony is to describe the proposed amendments to the Rule 20.10.2 NMEC and post-harvest processing, which we'll call the rule moving forward. And it is also Exhibit 1. for regulating the extraction, manufacturing, warehousing, testing, labeling, and transportation of human consumable, cosmetic, and inhalable products that contain hemp and are produced in New Mexico. This testimony will provide justification for the proposed amendments.
Why is the Bureau proposing these amendments now?
Earlier this year, the department promulgated an emergency amendment in accordance with Section 14-4-5.6 of the State Rules Act. The emergency amendment took effect on August 5th, 2025, and expires on January 31st, 2026, pursuant to the State Rules Act. Therefore, it's important that these proposed amendments go into effect before the emergency expire on January 31st of next year.
Why was the emergency rule promulgated in the first place?
The department's decision to promulgate the emergency amendments was based on its experience implementing the Hemp Act and rule, which led to the discovery of current and emerging manufacturing practices and finished products which were being offered to the public without verification or validation of their safety or efficacy. Specifically, the production and use of most semi-synthetic cannabinoids and synthetic cannabinoids, which I'll refer to as synthetics moving forward, such as Delta-8 THC, were banned by the emergency amendment due to the significant risk posed to both workers in the industry and inspectors and serious consumer health concerns.
Had the Bureau been considering amending the rule even before the emergency amendment?
Yes, sir. Beginning earlier this year, the Bureau began working on a comprehensive and updated rule, utilizing other state statutes and rules, national publications, stakeholder input, and public comments to complete the draft.
Please briefly describe the public participation and notice process for this public hearing.
Sure. Upon completion of the draft, the department filed a petition for hearing and held 2 public meetings to discuss the department's proposed changes to the rule, to answer questions and to receive feedback from concerning the proposed rule. During the public meetings, the department answered and/or received 30 questions and comments and received approximately 3 additional comments via email between October 7th and November 20th, which is in Exhibit 5 called Email. Public notice of the hearing was published in English and Spanish in the Albuquerque Journal on September 25th, 2025, which is Exhibit number 6. Public notice requirements in compliance with the State Rules Act as incorporated into the department's rulemaking regulations were met. Public notice of the hearing was posted in English and Spanish on the department's website, the Sunshine Portal's website, provided to Legislative Council Service for distribution, made available to the department's district, field, and regional offices, and was emailed to all current Cannabis and Hemp Bureau permit holders and other appropriate parties, which is, again, Exhibit 6.
What are the main objectives of these proposed amendments?
The first objective is to address current and emerging manufacturing practices and finished products offered to the public without verification or validation of their safety or efficacy.
Mr. Gerhardt,
Yes,
slow
ma'am.
down a little bit.
What was that?
Slow down.
Slow
when
down.
you read.
Very good. I've never been accused of being too quiet or too slow. So the second objective is to update the standards for production and transportation of New Mexico produced hemp products to meet current industry standards and practices. The third objective is to ensure consumers are properly informed of the contents and risk associated with the products they are consuming. The fourth objective is to create a more robust product testing program to further ensure consumer safety of products they consume. And the fifth objective is to more closely align New Mexico's hemp extraction and manufacturing requirements with other states' rules.
Could you describe the proposed amendments beginning with the definition section?
Sure. The rule contains 68 defined terms in total. The Bureau added 16 new definitions, including 2 that were added to the emergency rule. We modified 9 existing definitions and removed 4 definitions. The new definitions were developed by combining existing definitions from the Hemp Act, the current rule, and definitions used by other state hemp authorities. The changes to definitions provide clarification and specificity to requirements within the rule. An example of a term that was created for the rule is hemp retail manufacturer. The term was created to distinguish between the different permit types, one being a hemp manufacturer, another hemp extraction facility, and a third one hemp warehouse, and hemp retail manufacturing operations.
Thank you. What are the proposed changes to Section 8, General Operations?
The following updates are proposed in this section. Paragraphs 2 and 9 of subsection A were modified to clarify that facilities that possess an extraction, manufacturing, or retail manufacturer permit do not also require a hemp warehouse permit. Paragraph 3 of subsection A was updated to add retail food establishments in the department's jurisdiction, as well as food establishments in a home rule municipality, to the existing list of non-hemp operations that will require a separate hemp facility permit to produce hemp finished products. Subsection C, operational plans, was reorganized and reworded to match the department's current permit applications that underwent significant review and edits in 2025 to better serve applicants. Subsection D was updated to remove hemp processing facility as a permit type due to its lack of use to date. And we added hemp retail manufacturer as a permit type for food establishments such as restaurants and bakeries that produce hemp product. We added a $500 permit application fee for the hemp retail manufacturer. In addition, we added a $200 late fee for additional cost associated with processing renewal applications that are not received before the expiration of the permit. We increased the reinspection fee from $250 to $500, and we added a new variance processing fee of $300. And finally, the ability to charge administrative compliance cost. That's a lot in subsection D. Subsection E was modified to clarify that the department may take photos during inspections to document conditions on the premises of a hemp facility, and that permits will not be renewed until all outstanding invoices have been paid by the permit holder.
And what changes are being proposed to Section 9?
Section 9 contains requirements for employee health, responding to communicable disease incidents, designating a person in charge at the hemp facility at all times, and storage of personal care items at the hemp facility. The contents of this section were incorporated directly from the current food regulations, including multiple sections of the 2022 Food and Drug Administration Model Food Code. The following updates are proposed in Section 9. Subsection B was updated to clarify the requirement for hemp facilities to have management and employee training programs, and that those programs meet the minimum requirements outlined in this section. Subsection H adds a requirement for employees of hemp facilities performing job duties described in the definition of manufacturing employee to have a food handler card from a department-approved food handler training program. This requirement is consistent with existing requirements for cannabis manufacturing employees throughout the state.
What about Section 10, transportation?
Section 10 contains requirements for the transportation of hemp products by permitted hemp facilities. These requirements include designating where hemp products can be shipped, what documentation must accompany the shipment, and the condition under which the hemp products are shipped. The transportation requirements were simplified, which allowed the removal of less restrictive requirements when shipping small amounts of hemp product to analytical laboratories. Since hemp is federally legal, most, if not all, hemp facilities use common carriers to transport hemp product throughout the United States and the world. The updated hemp transportation manifest requirements were simplified to include information that is common on transportation documents and accompanying paperwork. The modified requirements still ensure hemp-derived ingredients are clearly identifiable and when necessary will have an accompanying certificate of analysis verifying the shipment is hemp-derived.
And section 11, hemp facility requirements. This section incorporates the changes from the emergency rule, correct?
Correct. Section 11 contains operational and product safety requirements hemp facilities must comply with for the safe and sanitary processing of hemp products as required by subsection 76-24-8.c2 of the Hemp Act, which includes provisions from the emergency rule. The following updates are proposed in section 11. First, the provisions addressing semi-synthetic and synthetic cannabinoids, again, synthetics, were incorporated from the emergency rule promulgated in August of this year. The provisions can be found in subsections K and L and prohibit, with certain exceptions, the production and use of synthetics by hemp facilities. The exceptions found in subsection L allow certain highly purified, non-intoxicating synthetics to be purchased and utilized in hemp production by hemp facilities. Synthetics such as Delta 8 have become increasingly common in hemp finished products that are consumed or inhaled. Synthetics are being manufactured and sold via a loophole in the 2018 Federal Farm Bill, and manufacturers are using toxic and harmful chemicals to produce these synthetics. The use of these dangerous chemicals pose a significant risk to the safety of both workers in the industry and inspectors and raise serious health concerns. All 50 states have had reports of adverse health effects as a result of consuming synthetics, which include one or more of the following: intoxication, agitation, hypertension, hypotension, abnormal heart rate, paranoia, anxiety, memory loss, confusion, breathing difficulties, seizure, and death. Between January 1st, 2021 and February 28th of 2022, the National Poison Control Centers received 2,362 exposure cases of Delta 8 THC alone. 41% of those cases involved pediatric patients under the age of 18. 82% of unintentional exposures affected pediatric patients. 70% of all exposures required healthcare evaluation, and 8% of those cases resulted in hospitalization. Regulatory and safety groups, including the U.S. Food and Drug Administration, the U.S. Centers for Disease Control and Prevention, and the United States Pharmacopeia, have issued statements of concern or warning concerning the consumption of synthetics. And these can be, those statements can be found in backup in Exhibit 7. Analytical laboratories currently lack standardized methods to properly isolate and identify the isomers, chemicals, and impurities that are created during the manufacturing process to create synthetics. Scientifically validated analytical methods developed through clinical investigations are necessary to ensure the isomers, chemicals, and impurities created by the chemical synthesis process are completely removed or exist at a safe level. Again, Exhibit 7. Finally, there is very limited consumer understanding related to synthetics. Consumers are largely unaware that the cannabinoids they are consuming are derived from dangerous chemicals, contain unknown and untested byproducts, and the potential to harm health from consuming them. This does not allow consumers to make informed decisions about the hemp finished products they consume. Exhibit 9. Second, another provision incorporated from the emergency rule promulgated in August of this year can be found in subparagraph A of paragraph 3 of subsection F. This provision requires hemp facilities to demonstrate that all hemp extract or hemp intermediate product received is derived from hemp. This provision helps ensure that cannabinoid extract and intermediate products that are not produced by the permittee are derived from hemp rather than cannabis, keeping the facility and product manufactured in compliance with the Hemp Act and the rule. Additionally, paragraph 4 of subsection F was updated to ensure non-hemp ingredients and the newly defined hemp intermediate product are subject to the same safety and sanitary transportation requirements as hemp and hemp extract.
Right. And section 12 of the rule is completely new, correct? Section 12 now contains the hemp finished product requirements.
Correct. Section 12 was reorganized to move water supply from this section to section 16. This was done to ensure that new product requirements were located next to product labeling, packaging, and testing requirements in the rule. Section 12 now outlines requirements for hemp finished products manufactured by hemp facilities. The requirements ensure that hemp finished products for human consumption have a defined serving size that is consistent with FDA serving sizes for food items. Subsection A limits the amount in milligrams of total THC allowed per serving and per package in a hemp finished product. Given the data available, the total THC per serving limit of 2 milligrams for human consumables represents a safe, non-intoxicating dosage. Please see Exhibit 8. Due to the fact that hemp tinctures and cosmetics are consumed differently than other hemp finished products, these products have different total THC limits. In addition, due to the unique nature of vaping, vape devices were exempted from the total THC limits. Additionally, new Section 12 requires permit holders to demonstrate that all hemp used to produce hemp extract, hemp intermediate product, or ultimately finished product was grown only using pesticides registered by the New Mexico Department of Agriculture for use in production of hemp. Permit holders must demonstrate that all hemp received does not contain residues of pesticides which are not registered for use in the production of hemp by the Department of Agriculture. Hemp finished products must be tested for pesticide residues as outlined in Section 14 of the rule.
Now, are changes being proposed to Section 13, the labeling and packaging requirements?
Yes, Section 13 outlines the requirements for labeling and packaging of hemp finished products and ensures there is standardization with related products in the marketplace and an accurate representation of the product to consumers. In addition to federal and state labeling requirements, the current rule requires labeling of CBD and THC content, which is specific to hemp containing products. Section E requires product concentration and content claims made on labels to be within 10% of actual concentration and content, which are required tests. Finally, in accordance with FDA requirements, hemp finished product labels may not contain medical, health, or benefit claims. The following updates are proposed in this section. New requirements for the principal display panel of a hemp finished product, which is the part of the label facing the consumer on the shelf, include the following statements or information. A statement the product contains hemp. Products that are not broad spectrum must declare they contain THC. And the total CBD and THC content per serving and per package. Additional new labeling requirements include an updated FDA warning statement and the allowance for the department to approve alternate statements. A statement recommending that those pregnant or that may become pregnant consult with a physician about using the product. A statement to keep out of reach of children. And if the product is not broad spectrum, a statement that it has the potential to cause a positive drug test and create impairment. Product labels cannot be designed to appeal to children and cannot be designed to resemble non-hemp products. Cannot contain cartoons or other images or symbols that are commonly used in the non-hemp marketplace, and cannot contain the words such as candy or candies. Manufacturers may use a QR code to display the required information in paragraphs 1 through 3 of subsection D, but must place the statement "important safety information" above or directly adjacent to the QR code. The intent of this statement is to draw consumer attention to the warning statements and ultimately increase consumer awareness of the products and risk associated with consuming that product. Product labels must be in English, but may also be labeled in other languages, as long as the product labels contain all information on the alternative language and English. This matches Department food labeling requirements that have existed since the year 2000 for all packaged food manufactured in the department's jurisdiction. Hemp finished products that contain multiple servings in a single package that require dosing by the consumer must have an accurate dosing device included by the manufacturer. This ensures that consumers have the tool required to consume a product in accordance with serving sizes as identified on the label. Finally, permit holders will be given 60 days from the effective date of the rule to implement the new requirements proposed in this section.
All right. How about sections 14 and 15, which are the laboratory testing requirements?
The following updates were proposed to section 14. A pesticide profile that will be determined and maintained by the department will be required for all hemp finished products. The department has researched pesticide residue testing requirements for multiple states and is actively working with multiple stakeholders to determine a pesticide profile panel that will meet the need in New Mexico and be the most cost-effective for analytical laboratories to utilize. The department-approved panel will be announced to permit holders and approved analytical laboratories before the effective date of the rule. In addition, in the future, permit holders and approved analytical laboratories will be notified at least 90 days before the department changes the approved panel. Analytical testing results must demonstrate that human consumable products are equal to or less than 2 milligrams of THC per serving and 20 milligrams per package, and tinctures are equal or less than 100 milligrams per package. This ensures products meet the new potency limits established in section 11 of the rule. Pesticide residues for NMDA registered pesticides must be equal to or less than EPA limits set for each chemical and pesticide. Residues for chemicals not registered by NMDA must not be detected in the product. When a product fails to comply with testing requirements, a retest of the original product may be done by the analytical laboratory. When a retest is required, the analytical laboratory and permit holder are now required to independently notify the department within 24 hours of the completion of the confirming test. Finally, permit holders and approved analytical laboratories will be given 60 days from the effective date of the rule to implement the new requirements of this section.
All right, we're nearing the end. Section 15 of the rule, what about that?
Section 15 requires hemp permit holders to test their products pursuant to section 14 of the rule and utilize a laboratory approved by the department. The only amendment we are proposing here is to subsection C to make it clear that approved analytical laboratories must independently notify the department within 24 hours of the completion of a confirming test when a product fails testing limits.
All right, and new section 16 where the water and sewage requirements were moved to, what about that?
Correct. Section 16 in the rule was previously section 12 and outlines the requirements for a hemp facility's water supply. In addition to the current requirements, it is proposed that hemp facilities will be required to dispose of sewage in accordance with applicable laws, including 20.7.3 NMAC for those that dispose sewage via an on-site liquid waste system. This was added for clarity and is currently a requirement for applicants and permit holders by other laws and rules, so it does not constitute a new requirement.
And finally, sections 17 through 24, are any changes being proposed to any of those sections?
Yes, there are minimal changes being proposed. Would we like to go over the minor edits for each of those sections?
If there's something that's really substantive, I would say.
I don't believe there
I
is.
think most of those are
Yeah.
just kind of cleanup language.
They are in simplification
And,
of internal processes for report writing.
And those are covered in the written testimony. So we'll that concludes our presentation, and we are standing for questions.
All right, I have a question. I saw recently that the federal government had taken some action around hemp, and I'm wondering if that has an effect on this rulemaking.
Go ahead.
Yes, ma'am, you're correct. They put what was called Section 781 into the continuing resolution bill that was signed a couple of weeks ago. And that does have a major impact on the hemp industry nationwide. Essentially, if I could break it down in a few simple points, the first and most notable is that these synthetics that we are discussing have been completely banned by the federal government in the hemp industry in the US. They also have additional provisions that redefine hemp to exclude synthetics from that definition. And they have also now defined container and are awaiting the FDA, the Federal Food and Drug Administration, to clarify what container means. And the final provision of that rule was that the FDA come up with a list for several lists, including intoxicating cannabinoids, non-intoxicating cannabinoids, cannabinoids that are or can't be found in hemp, and cannabinoids that are created outside of the hemp, any of the naturally occurring hemp cannabinoids.
Thank you for that, Mr. Gerhart. Are there other questions of Mr. Gerhart based on his testimony? Ma'am, tell me your name. And 11? We need you in front of a microphone. You can come to this one here. And I will ask you to spell your first and last name for the transcript.
My first name's Anna, A-N-N-A. My last name is Levin, L-E-V-I-N.
Thank you.
So my question is back to the federal ban that just was written a few weeks ago. So it's my understanding that no product can have more than 0.4 milligrams of THC in any container. Is that something that we're thinking about moving forward, or are we just going to wait and see what happens?
So this current rule was in effect and testimony was provided and the rule was provided before this happened. It was literally the day before we submitted everything. The state is currently in the process of evaluating what direction the hemp program in New Mexico will take come next November when the federal law is effective. And so the answer is that is on our radar. It's being discussed, but we don't know what that would look like a year from now.
Makes sense.
And
Thank
I'm glad you brought that up, by the way, because that was one point of the federal law that I forgot to mention. We are proposing 2 milligrams per serving, and the federal law, as she stated, was proposing 0.4 milligrams per serving, which is much less than we're currently proposing. But right now, it's important to note that there are no limits whatsoever in New Mexico law for hemp products, which means they can exceed the milligram dosing of legal cannabis products. So again, we're trying to make a clear distinction between the hemp and cannabis industries, and that's going to be a big point that needs to be addressed. in roughly 11.5 months before then.
Yeah, we'll see what happens. I appreciate that. I have one more question if you don't mind. So when I read the addendum, it said that no manufacturing facility can make any product that has, I think you said 2 milligrams per serving. Would that include any hemp beverages or hemp products that are made out of state? Could they be sold within the state of New Mexico that exceed that limit?
Currently, the department does not have jurisdiction over the retail market, hemp market in New Mexico. And so the answer to your question is yes.
So
They can be sold in New Mexico if they are produced
outside
outside
of
New
the state.
Mexico and exceed 2 milligrams per serving.
So
Currently,
it-
they can be.
Okay, so if something's made in, say, Pennsylvania and it's shipped to New Mexico and has 10 milligrams per serving, that's fine. But as a manufacturer, I can't make any, in New Mexico, I can't make anything that's 10 milligrams per serving.
At the moment, correct.
And with this new legislation, would that be possible too? Is that what we're saying?
Well, right now the department only has jurisdiction over the extraction and
Right.
manufacturing. So we're doing what we can there. There have been efforts and hopefully there will be more effort in the future to address retail hemp products in New Mexico. But until that happens, until that change is made, we can only regulate what the legislature has given the department authority over, which is extraction and manufacturing.
Got it, but it doesn't have anything. We haven't addressed the retail portion of it yet.
Correct.
Got it. Okay, thank you.
Thank you, Ms. Levin.
Thank you.
Are there other questions for Mr. Gerhart based on his testimony? Mr. Knight?
I have no additional questions.
Okay. Questions from anyone else? See anything? All right, well, thank you very much, Mr. Gerhart and Mr. Knight. Let me ask now if there's anyone in the room who would like to offer non-technical public comment. Non-technical public comment. Is there anyone on the platform who would like to offer non-technical public comment? Please raise your virtual hand. No one? Right, Louis says he sees no one raising their virtual hand. In that case, we will admit all of the exhibits that were submitted by the department with Gerhardt's testimony and the notice of intent. I will wait for the transcript. I will write a report, forward the entirety of it to the cabinet secretary with a draft final order, and we'll proceed from there. So thank you all very much. And Mr. Knight.
Thank you, Madam Hearing Officer.
Of course, we'll adjourn then. Thank you all.